They don't come in. They don't come in, the end of the case. Because it's within, of course, it's within the discretion of the court to let it come in late. But a court would be hard pressed to do that when you set it up so perfectly. And if a judge is abiding by his own orders, and you make that an order of the court, he's precluded, especially on something that's so important and so dispositive. The judge might say to you, by the way, that's a third offense, minimum mandatory 150 days. I'm gonna give him the same 150 days. Why you wanna go through the exercise? Why? Because unless he's convicted of it, it's not a felony, even though he does the 150 days. Unless he's convicted of it, he can participate in all the programs of the institution, including work release, bracelet program, all that stuff, which he would be precluded from participating in if he was in a third offense, because he gotta do every day except for his mother's funeral. He's gotta do every day. Don't have to do that, because it's no longer minimum mandatory. 150 days no longer means 150 days. If you can get around that issue of them proving he was the same person, it all comes back to your pretrial office report and discovery. Okay, so the next question is, everybody understands it, by the way, 218.26a. Gotta be relevant. You have to go to the, by the way, you learn all kinds of stuff from going to police stations. Don't look at it as onerous. Look at it as an opportunity, as education. Because I've gone to police stations, they say, oh, you got one of officer so-and-so, what a flake, this is what he does, and they don't like each other, they're like, oh, ladies, you find out all kinds of stuff. One of the things you ask for is something called the audit sheet. Now, Chapter 90C requires, it's a no-fixed ticket law, that they keep an audit sheet, and they're not disclosing atomic secrets. It's public record. The Boston Globe can go in and get it. It's a public record. It's in the statute. It's a no-fixed ticket law. But it gives you a sense of how many tickets this guy writes. Now, there are some people, there's one particular trooper who goes, testifies in Somerville all the time. He pays his mortgage on 2 pinches, 3 pinches a week for OUI. That's where he makes his money, because he's a night officer, he gets his court time, and he grinds every one of these cases. And every one of his reports looks the same. Every one of his reports looks the same. You want some of his other reports. And you get that by talking to other members of the bar about who this person is. It'll pop up on the audit sheet, you'll see. Most audit sheets, if they make 1 pinch a week for OUI, that's a lot. But if you see one making every night, no cop is that good. They're not that good. So there's something going on there, okay, with this particular officer. There used to be a cop in West Roxbury before you folks were judges. And he was notorious, everybody knew his name. He made me a ton of money, okay? Paid for my kids' braces, all at the same cop. And I had all his reports. These people would get there, represent the people in the same neighborhood, and they'd come to me. All of this is now, it wasn't at the time, now discoverable. So, what are the things that you look for? Well, first of all, it's basic stuff, and you can go through the list, and I'm not gonna read you my own motion. But some of the more unknown things are the booking materials. By booking materials, it might be an envelope that they put their valuables in. Then they put down the time. The guy who is the turnkey, his life's work is making sure the guy doesn't escape, making sure that the guy doesn't commit suicide, and to make sure that he isn't accused of stealing. So his times are gonna be accurate. But the cop in his report, and the citation might have one time, the report might have another time, and the guy in the station could be having the time when on the report, the guy's still out on the road. Those are issues of reasonable doubt which you would never have come across had you not asked for it. What kind of envelope? How can an envelope be important to someone who's under the influence? Goes to the credibility of the arresting officer if it's inconsistent. You never know. The more material you get, the more stuff you find. And the DA is at a disadvantage, because you think they go and make copies for the DA, they never do. They show up that day, the DA has 9 cases, all of which are set for trial. If they're lucky, he scanned the files the night before, so he knows the names of the players, talked to the witnesses maybe over the phone, and the DA doesn't know. It's like lottery. Like I said to you before, they'll try 2 cases at once. One jury waived and one with a jury. How the heck do they keep track of it? They can't. You have an incredible advantage. That being the case, you have to know what to ask for. Now, Dr. Benjamin is going to tell you about the machine. You have to know what to ask for in the machine. Now they have it where you're going to be able to do it online. You're going to be able to find everything about the machine, but not enough. What they want to give you is never helpful to you. It's never good, okay? They want to tell you that your client blew a .19, and that the machine is wonderful, and the simulator is terrific, and everything jives, and the computer chips worked, and all that stuff. However, they don't tell you that there's a guy who, it's a Draeger machine, there's a guy in Germany who's president of the company who testified before a Dober hearing down in New Jersey who says you should only use the machine 45 times a month before it starts to fail. Well, that's one test. We do a two-test protocol. That's 22 times a month. You do it more than 22 times a month, the machine is vulnerable. Do you think they tell you that? Do you think Nancy Burns will tell you that it's vulnerable just for that reason alone? He's going to tell you all kinds of stuff about people blowing into the machine. As you get older, your ability to blow into the machine becomes more difficult. And these so-called insufficient samples, the significance of that. Well, you have to know what that's all about. So you need the manual from the machine itself, not the one the state police publish, because that's proprietary, excuse me, because that's what they want you to see. It's part of their infrared breast testing course. All this stuff is foreseeable that it will get into the defense hands. It's all very self-serving. You want the one that the machine manufacturer publishes that talks about all of the warranty claims and all the disclaimers and all of the added options. If you don't have this, you can't do this. You don't have a mouthpiece that does such and such, you can't do this. You want all that stuff. Think about cross-examination on this flawless, perfect, wonderful machine where they're changing the models every 6 months because of their new and improved versions, okay? So all of this is discoverable. If you have a blood case, you want the chain of custody, you want the protocols, you want all the stuff that involved with the blood. There's a whole issue on blood. And Kevin will talk very briefly. By the way, this is Kevin Reddington, see this distinguished gentleman sitting right there? He sat the longest with his mouth shut that I've seen him since I've known him. But he will enlighten you on this, and I'm gonna have him join in a minute on the discovery business. So, be as creative as you can as long as you can tie it into relevancy. As I said, audit sheets are very remarkable in telling you who the police are and what they're all about. You want to know everything that the defendant signed. You want everything that relative to the case. Plus you want the log. It's something called an administrative journal. Boston Globe sued the police departments in the past and was successful to show that that's a public record. So they're not giving up anything. So you're entitled to a non-redacted version of the log in the administrative journal because it's a public record. Now, why is that important? Because it gives you, it gives you roll call. Simple thing like roll call. You want to know how long the cop has been up? You might be on a second shift. You might be up for 24 hours straight. He's blurry-eyed. He doesn't write his report till 3 or 4 hours after that. You want to know that. You want to know where the other officers are. You want to know if they're on other calls. You can say, I was assisted by Officer such and such, but he was on the other side of town, according at least to the log, and the log never lies. The police are laughing up there. They know that the log never lies, right? Anyway, the point is, you want this stuff, and you might want to run it by some law enforcement friends to have them interpret it for you. You'll find out stuff, but they can look at things and say, wait a minute, this isn't right because of, just like you use an expert witness as a doctor who can interpret things on a medical report. They'll see things, if you're new at this, on a police report that you might not be obvious to you. Okay. Any questions on discovery itself? Because I want to have Kevin join in on this, but on the issue of discovery. Everything relevant is discoverable. That's the test. Not burdensomeness, not onerousness. The second part of it are motions in limine, and I won't get into the motion in limine on the .08. You've already talked about that a little bit. I try to find a reason to file a motion in limine in every OUI case. What is a motion in limine? A motion in limine is asking the trial judge to make an evidentiary ruling prior to the start of trial. So what does it do for you? It gets you to talk to the judge. You might go, I don't know about you folks, but I go all over the state trying these cases, and half the time I don't know the court. I'll have to go to Springfield, I'll have to go to Palmer, I'll go to courts that I never knew existed, Orange. And I don't know these judges, and sometimes I call local counsel to find out what they're all about. But it also gives you credibility. You file a motion in limine on some issue, asking for an evidentiary ruling. The judge can do one of three things. One, can allow it, and that would exclude comment on it by the DA. Two, can deny it, which would allow comment on it. Or three, reserve. In other words, not making any ruling, waiting to see the context in which it comes in terms of trial. But what does it do for you? It starts the rapport. It starts the credibility. You have to have credibility with the court before you ever get to establishing credibility with the jury. You want the court to know that you know a little bit about this stuff, and that you're respectful, and that you get a sense by that initial talking about it. I try to do it in the lobby, although a lot of places don't do lobby conferences. But I try to do it in the lobby. It's much more informal with the DA. And you schmooze. And the next thing you know, you got some kind of a rapport, you've built up that credibility, and I use it through the vehicle of a motion in limine. Now, motions in limine can be very sophisticated. For instance, breath test devices are excluded based on a motion in limine, not a motion to suppress. Many of you feel that you have to file a motion to suppress. A motion to suppress is a judicially imposed remedy involving the Constitution. There's no constitutional issues in excluding a breath test, at least that I'm aware of at this point. So what you're doing is filing a motion in limine. By definition, motions in limine are heard by the trial judge. Although, if you're going to have a one-day hearing on the problems with the machine, they might allow a separate day before a different judge, and you let the court know that that's what you want. But aside from motion in limine, what are some on the breath test? And many times the breath test is the case, especially with this per se business. Others are, and I gave you a couple of examples, there are dozens of them. They go through the car and they find all these beer cans. Now, some of them are frozen solid, and they've been there for so long. Others look like they've just been drunk out of. You gotta look at the facts. And you have a motion in limine on whether or not they should be commented on or excluded, because they're not, if the person's not being charged with open container, and things of that sort. That's one example. Another that you can always use is the term sobriety. Now, sobriety has come into our lexicon, our language, as such a common phrase that everybody really knows what it means. But if you take it literally, those tests don't have anything to do with sobriety. They have to do with coordination. And if you want, and there was a standing order in one court, I think it was Concord a few years ago. You didn't have to file a motion. There was a standing order not to refer, for the police not to refer to the tests as sobriety tests, but tests of coordination. And so that is there's a viable motion. Some judges will exclude it, some judges, let them have it. They'll call it sobriety. We all know what it means. So it's a judgment call, but it gets you into the discussion. It gets you into the rapport with the court that you're trying to achieve. Any questions on any? Yes, sir. Yes, Nelson.
Dick, I'm sorry, a little slow on the trigger. This is really a discovery question. I should have asked you 10
Sure.
Do you have any effective way of getting to the numbers of complaints that this particular officer has filed in a particular court, and how many dismissals there are on those particular?
Well, you got to do your homework. What you have to do is you do the audit sheet first. The audit sheet, every Chapter 90 case, every OUI case under Chapter 90, you have to write a ticket. And you ask yourself, why do you have to write a ticket? He's under arrest. But that's the law. He has to give him a ticket. You can even mail it to him because notice has been provided by the arrest. So you check the audit sheet, and that will tell you the number of arrests, and then you go to the court. And then you might somehow cross-reference it. I don't think a judge, unless you have some basis, will automatically, because it's not relevant, unless you can make it relevant, say that this guy is making an inordinate amount of arrests and uses the same police report. But what you do is you talk to local members of the bar. Let's say it's in Rentham, or let's say it's in Dedham. There are certain lawyers that are in that court all the time and say, officer, so, oh yeah, I've had 2 or 3 cases with him. Can I see his reports? Do you have any of your files? You do it that way. Once you have something, then I had a situation where the form that they use for the 263-5A rights, that's the right to a physician. There are 2 immediatelys in the statute. You should be immediately informed and be immediately given the opportunity. So they immediately be informed, immediately given the opportunity. For some reason, the state police, I don't know if they did it intentionally, I'll give them the benefit of the doubt, but they don't throw out anything. They left out the first immediately, which changes the whole context of the sentence. He shall be informed that he has a right to an immediate examination, but it doesn't say when he should be informed. So, and you look at the context of the sentence, it doesn't make sense. They never threw the forms out. So, for months and months and months in Marlborough, out in Lowell, in Worcester, and down in Middleborough, they were using that form. And I'd have a brief and a form all prepared, and the judges would deny it until I came to Marlborough. In a Marlboro, the judge says, I want to see if they've been doing it before. If you can show me they've been doing it before, I'll consider it. Sure enough, I was able to look at all my other files, and I filed these motions. Filed an affidavit, addressed it, attached the form. And he dismissed the case as misconduct, okay, because they did it intentionally. It wasn't just a mistake or neglect. But that's all from discovery. It's all from discovery. Yes, sir.
Since you're on that line, what about the 263-5A, the forms that say you have a right to an attorney, and if you want to call them, you can call them, and then the next line says, you can make your phone call within an hour.
Okay,
It says it on all the forms, I don't know if anybody's noticed it.
right.
I've got a videotape where my guy asked for it 4 times, they said, no, the hour's not up yet. He wanted to call me about taking a
Well,
BT.
then you have a Miranda issue, don't you?
I don't think it's a Miranda issue, I gave him his rights. What he wanted to do.
No, what I'm
was-
saying is he exercised his rights. He wants his attorney. He wants to make his phone call.
My
You have a
point-
Miranda issue, everything must stop. Your question is, they're recording this, so I have to repeat your question. Is on the form where it says you have a right to phone an attorney within an hour.
No, he tells you, you have a right,
It tells you early.
you have a right to have an attorney. You
Yeah.
can stop anytime you want, call an attorney.
Right.
And it says, you can use the phone, but we're gonna have you wait an hour. It doesn't say those exact words, but I think
Yeah.
everybody's seen those forms. It says, you can make a phone call within an hour. How do you call an attorney when he's giving you your
Correct.
PT rights right away?
Correct. And I don't know
You
how,
have to wait
I don't know how a judge would react to that. I know at a minimum, it's a Miranda issue, because he's been given Miranda rights, he's now exercising them. What do you do after that? Okay. Kevin, I know I've stimulated your interest, you're making notes on who to play at the track, but I mean, I want you, could you
Absolutely
comment?
right.
You're unique in your discovery approach. Would you help us out?
I would like to just follow through on the comment here. I thought it was a good point, and I know exactly what you're suggesting is that under the Rhode Island versus Ennis case in that line, that once the defendant says that he wants to speak to counsel and apparently said he wanted to talk to you 2 or 3 times, anything after that goes out anyway. So I think maybe the issue on the telephone rights might not be all that relevant because, quite frankly, you got a real good motion to suppress and throw everything out from that point forward, I would think. I think when you're dealing with the discovery issues, I do have a little bit of an unusual approach, I suppose, and my way of looking at it is that what you really want to do is investigate and investigate and investigate some more. These cases are limited only by, I guess, the financial resources of the defendant. I think in any case involving an OUI, one of the things that you want to do before you even go into court and get into the formal discovery aspect of the case, you want to get a weather report. I mean, they cost like $25.
The one with the gold seal on it.
Yeah, it looks formal, it looks fancy, and if you want to have Fred Ward, you can pay him a couple of $100, and the juries all think it's great. But I mean, I can't count how many times the issue of weather was important, and a police officer may say, well, I don't remember, because they're out there night after night after night, and unless they have it written right down in the report, they may not recall that it was sleeting and rainy, or perhaps very, very cold, which of course you can argue can impact on the dexterity exercises. I think that it's important to get photographs of the scene. Never mind, having the DA do it, go out and get photographs yourself. Now, here's where you say to the client, I'm building a house for you. It's up to you if I'm going to use good tools or I'm going to use crap. I mean, if you want to pay me, $2,000 or, whatever the freight may be, I'm not going to be able to hire a private investigator for you unless you want me to hire one, and I'll get a cheap one. If you want a good one, you're going to have to pay them $500, $1,000 to go out and just take pictures. They're going to go out, right out, they're going to take pictures of the scene. Get some videotape footage of it, especially when you're dealing with the state police, when they're stopping cars on the side of the roadway. You can't believe the impact that a videotape, and this is different than taking a jury out in the middle of the nighttime or asking for a nighttime view or something. If you have a videotape of the scene, and at the same time trucks are going by with that whooshing noise and cars are going by, and if it's a rainy night, and it was a rainy day on your arrest or a rainy night on your arrest, I think it's very effective. You hear that noise, and the juries are able to visualize.
Just to lighten, expand on that. Picture a 9-step walk and turn, everybody knows what that is. On the white fog line, and that's their words, fog line of Route 495, with tractor-trailer trucks going by at 70 miles an hour, and you can't even stand still without being blown over, and it being 10 degrees, and it being blowing 25 to 30 miles an hour, and he's asking him to stand on one leg or walk 9-step walk and turn, and the question is, officer, you mean to tell me if he fell to the left, he would fall in the travel lane? And,
They would say they'd hold him up.
yeah, so the penalty for OUI for the state police is death.
Yeah, go ahead, Kevin. Yeah, that's right. Yeah, step right in. Go ahead, Kevin. I'll follow through on that. I'll be the straight man, okay? No, actually, and I think that is effective if you have the photographs. I mean, you can go out and do it yourself, actually. You can take the photographs yourself. I think what else you might want to consider doing is, after you've investigated and you've filed all the requests for the documents and the records and the Chapter 90 forms, you now file your motion in court. I remember a number of years ago, I got a phone call from Dick Zisson, and he said, I heard you have a pretty good discovery motion, Kevin. I'd like to have a copy of it. And I faxed it to him, and I've seen it cropping up all over the place. Actually, I'm only kidding. But you then file the discovery motion that you've already seen. It's in the materials. And then you file the request with the court to get access to it. And I do agree, you should attach it to the pretrial conference report. I think it's very easy, and that way DAs are able to look at it, make it part of the record. The judges, who are generally quick to say, you know, pretrial conference carries the same effect as a motion, wonderful. And most of them will exclude evidence if it's brought up in the middle of the trial and it hasn't been disclosed prior to. And I like that 30-day order. I always write in 30 days for government, 10 days any response prior to trial for the defense. I mean, it cuts two ways. You have to be fair about it. I do like the idea of the motions in limine. I do disagree with Dick just a little bit. I do like motions to suppress. I think motions to suppress are a gold mine of information. I think that any attorney, especially if you're dealing with a serious case, you know, motor vehicle homicide or a third or fourth offense OUI, or even a first offense OUI where the client is telling you, look, this is a scorch and burn policy, then I would say that you've always got a basis to file, whether it's voluntariness, Miranda, a motion to suppress. You can
I
file.
think you misunderstood what I was saying. Motions to suppress do not exclude breathalyzers, but there's always a Miranda
Well, I was
issue.
going to get on that
Yeah.
and comment that you still have a right to file a Daubert motion, and you can file a motion in limine on Daubert, and one of the issues is reliability. And what does that mean? It means that you should be able to, and maybe the judges can answer this better, but you should be able to, I would think a judge would allow you, to cross-examine the administrator of the test, to his qualifications, things of that nature, whether it's a Daubert issue on the field sobriety, the dexterity exercises. I think you should be able to cross-examine on the administration, the results of the test. And again, subject to the money you have a stenographer. Don't rely on the stupid tapes in the district court. They don't work. You hear doors banging and people dropping stuff, and sometimes there are lapses. You have to bring a stenographer. It's going to cost you $150 for an appearance fee. You can then request the tape, and you've already got the stenographic backup of it on a motion to suppress. You have to then use that, obviously, give a copy to the DA at the time of trial on the cross-examination of the officer. I think it's invaluable. So you're going to be able to raise through motions in limine and motions to suppress all of the things that the DA so rightfully object and say that we're looking for fishing expedition. I mean, that's what we're doing, obviously. So I would feel that the other benefit, by the way, which I know I'm not supposed to say, is that many times you can have the judge make a decision and then say, if it's a bad judge, you say, Judge, God, I'm waiving a jury on this, and I know you really can't hear the case, and maybe you get to the good judge that's in the courtroom right next door. It's another tactical consideration.
Never in West Roxbury.
So those are my observations, Dick.
Good, thank you. Fair comment. What do you folks? Yes, sir.
The videotape of the area, how do you get around the fact that the DA is going to say that's not representative of the night of the arrest?
I would say on cross-examination, you say to the police officer, give me a description of the night of the arrest. Okay, you got the road, here's a photograph. Photograph fair and accurate representation? Yes. You got the dark sky. Did it look that dark? Yes, it did. Okay. Raining out, not raining, snow, whatever. Problem maybe if you have snowbanks and stuff, I suppose. But I think a fair argument can be made that this is representative of the scene, rather than taking the jury out and having them look at it at 2 o'clock in the afternoon. We're talking about a nighttime arrest. Now, could a judge say, look, it's not representative of that night, Yeah, I suppose they could, but if that's the case, then you shouldn't be able to introduce a photograph taken by the state police 48 hours after a motor vehicle homicide of the roadway. You see what I mean? I mean, to some extent, people might be able to object to bringing a jury to the scene of a murder at 2 o'clock in the morning, because there are all sorts of different things going on at that point. And as I think about it, I suppose the DA could very well argue, well, Judge, you know, we don't know how many tractor trailers were whooshing by and things of that nature, so maybe you turn the audio off. But, I mean, that's up to a judge to make a
That's the
ruling on
exact-
that.
I tried the videotape twice years ago when I was, so what do you think you are, Cecil B. DeMille? You know,
No, you're in the background going,
how do we know there were that many motorcycles and tractor trailer trucks going up there that night?
You should have been in Laconia.
Sandra, do you have any comments on this whole discovery? Your folks had to respond to it as DAs.
Absolutely. I think certainly no one wants to go to trial by ambush, and the requirement that discovery be given in a timely. And the
We're very
requirement-
high-tech here. You got it on? Okay.
The requirement that the discovery be given in a timely fashion is certainly important. I think there's really, there's nothing that can substitute for, again, for investigation of a case, be that on the prosecutor's part or on the part of defense counsel, because certainly when you're taking that case, if it's going to court and if it's going to go before a jury, allowing them to see as much as they can is only going to help.
George?
Yeah, just briefly on discovery, at page 87, this is a breath test case discovery motion. Strategically, I formally file it all the time, and when I get to court, I'd make an agreement. I wouldn't force the Commonwealth to produce the records. I'd make an agreement to go to the whatever police station it was. What that accomplished was, I'd go to the station, I'd get to see the records, see if there was any kind of error in the record keeping, and the DA would never go out and get the records. So I'd be one step up. So if I forced them to produce the records, their breath test records, which usually were in compliance, they'd have a copy in their file. So I'd say, well, why don't we do this? I file the motion, why don't I make an appointment, I'll go out to the station and look at them. What's interesting is that the Office of Alcohol Testing is now, and Dick is absolutely right, whatever they give you, it's probably not gonna help. It's at page 64. This is the new breath test record request. It's really very interesting. I just found out about it just before the book was put out. Another lawyer forwarded to me. Now, if you have a breath test case, it's DAs that are up on it are saying you don't need the motion because although we're not online yet, you can get those records from OAT. So you fill out this information on page 64, you fax it over to the Office of Alcohol Testing, and within 7 to 10 days, they forward back to you a disk for your computer. And on the disk is an enormous amount of information. It's brutal trying to figure it out. The way it's formulated it comes out on your computer, it's in a spreadsheet manner. It's so difficult to read. I'm going to go back to the motion. I'm going to go back to going to the police station. I mean, I've got two of them. You're muddled in all of this, a ton of information. But they do give you all the prior tests. They do give you all the prior calibration tests, all the periodic testing. They do give you the Dragger book that the police department receives. So you get that, the manufacturer's literature. So if you get one, it's worth filing the request. And when you file the request, the DA's not filing the request. My question becomes, if I get information and I find something discoverable, I think I have to forward the disk to the DA. I don't have to point out the problem that I find. I can let them put it in their computer and spend 2.5 hours trying to figure it out. But
Assuming they have a computer.
yes, that's correct. So this is a whole new thing, this request form. And they're making like they're giving you something, and you do. You get a ton of stuff on the disk. To print it, it was 1,100 pages. There was 400 pages on one area and 700 on another. So I'm of the belief that you keep it simple. The less you have, the better off you are on discovery. I'm a pretrial conference report guy. I'm not heavy into motions on the OUI because I think what they give you, you can work with. I think Dick is right. Time factors are tremendously important. On a breath test case, I always go to the time on the citation, time on the police report, time on the statutory rights form, and then time on the breath test ticket. You'll often find that on the time on the statutory rights form is not 20 minutes or 15 minutes prior to the time on the test ticket. The officer or the trooper, he'll write it up at a different time, so you always have the cross-examination then with the statutory rights form. So you gave him the statutory rights and you put a time on it, didn't you? And this time is located there. And that's 10 minutes prior to the test. Well, I advised him of his rights as he sat, and this is an honest answer. I gave him his statutory rights form when I placed him in the rear of the cruiser. But you've got to cross on that issue. You often see it on the statutory rights form. A trooper will put a time, it's either within the 15 minutes or it's way outside the 15 or 20 minutes, and it gives you some ground to do some cross on the breath test, because normally there isn't too much you can do. So you want to look at all the times, and you get that material. The other area that Dick touched on is the prior convictions. You go back to that complaint, and that they charge him as a multiple. This statutory change in proving the prior convictions is very troublesome.
Allows them to amend, by the way, right prior to the commencement of trial.
It's, I just put the term Dick used on my pretrial conference report, documents. I never identified, because maybe the DA's, maybe he or she has 50 cases, and they're not even gonna look at the complaint until the night before, the day of. You don't wanna tip them on a pretrial conference report that you're specifically looking for certified copies of prior convictions. So I just put documents. So you look at that complaint, and he's a fourth offender. He's not charged as a fourth offender. Do they have the right to amend? Don't forget, the Commonwealth always has the upper hand. If they're within a good period of time, I've had them come into court and say, I'm not going to agree to an amendment. You haven't even given me the documents. They say, you know what we're going to do? We're going to null cross the complaint. We're going to take out a new complaint, and we're going to take it out for third or fourth offense, whatever it is. So when you look at it, I never asked for the documents. I just use that one term, document. I see if they produce it. Now it's there. They properly charge you. They charge you as a fourth offense, and the Board of Probation shows you to be a fourth offense. I filed a motion right on the trial date. It's a standard motion to dismiss so much of the complaint as alleged fourth offense. You say to the judge, they can't prove it. We're here for trial. They don't have it. I'm ready for trial. Let's go forward on the first offense. Or if you have a judge that's listening, you say, Judge, I'm willing to admit to sufficient facts on the first offense. What can I get? What are you willing to do? There are judges around it. If that's this lifetime look back, I've had a number of people come in, and 20 years ago they had 4 priors. This guy's a fifth offense. I mean, he's looking at a mandatory. So it's all how they charge it. If they charge it, can they prove it? That amendment to the statute on the certified copies of probation records is truly troublesome. I don't know if it overrides Commonwealth versus Coney on the identification. I'm not sure if they need to bring in a live witness to say that's Joe Jones anymore, but it's certainly troublesome. But I agree with Dick. Never admit to a multiple offense if they can't prove it. Once you get to that third, it's a felony. It's a true bar to many avenues of employment and all other aspects of life. You get that third offense, you're a felon. You're going to look at it if you're going to be a lawyer. They're going to look at it if you're going to be a certified public accountant. They're going to at least look at it. So never give up the multiple offense. Always fight it throughout the entire, the whole process. When I interview a client and I ask them, on your prior offenses, where were you convicted? When were you convicted? Did you have a lawyer when you were convicted? Dick spoke of Concord District Court where the term sobriety couldn't be used. That was a good ruling, but that same judge was also a judge who, if you didn't have a lawyer in your second offense and they couldn't prove waiver, he ruled that you couldn't use that to enhance the penalty. So you always want to know whether or not they had a lawyer on any of the prior offenses. They don't really need one on the first. On the second, if they're subject to a jail sentence, the Commonwealth, in my opinion, has to prove that they had counsel or effectively waived it.
Judge Coffey, how do you view discovery in your court? How do you rule on some of these requests?
On the motion for, well, I've never had a request for excluding or limiting the Commonwealth to using a term as a field test as opposed to a field sobriety test.
The word
And
sobriety, yeah.
I would not be inclined to grant that motion.
Mm-hmm.
In large part because I think there are many cases, McGrail comes to mind, the Shute case, as well as the Sands case, in which the Supreme Judicial Court, as well as the Appeals Court, has adopted that language, field sobriety test, and they have recognized and articulated that they are a means to test coordination, balance, and accuracy. And so, therefore, I would not be inclined to grant the motion. But I did want to comment on a few things, and that is the most effective cross-examinations that I have seen in dealing with field sobriety tests are when a defense attorney has secured a copy of the training manual that particular police officer was trained X number of years ago. And I think it's very persuasive before a jury if you can show even the slightest deviation from the way it should have taken place. And I don't think that it's really that hard to do, and I hate to sound like a financial, obsessed with finances, but it's a low cost and very effective tool to get a hold of that manual.
No
And
cost.
it's something it's an investment, because once you get it, it's applicable to many, many cases. The other point I wanted to make, and I don't think it should be lost in the discussion, is the fact that Barbeau, Commonwealth versus Barbeau, and that a defense attorney should always file a motion ensuring that the Commonwealth is in compliance with the periodic testing of the breathalyzer. So this new statute, it changes some things, but at the same time, the basic approaches that have been used effectively should not be overlooked.
What's interesting and Kevin's gonna demonstrate how you neutralize, and that's really what it is. It's not destroy, but neutralize the impact of the direct exam of an arresting officer. And there are about 10 things. The manual is 142 pages, but there are about 10 things in that manual that are very helpful. And every time they amend it, they take out one of those 10 things. They're down to about 8 things now. But they have to give you certain things. And one is that you look out for the safety of the defendant. That is paramount, the safety of the officer and the safety of the defendant. This whole business about using a line on the side of Route 495 just flies in the face of how someone could perform anything absolutely sober under those facts and circumstances. That's just one item. I'm not going to get into it now because I hope that Kevin would be able to raise as many of these things as possible. By the way, many times your client will have suffered injuries way back when, but leaves him with some kind of a residual, like a skiing injury, a football injury, a knee, anything to do with the knee, anything to do with the back. There's something called 233, Section 79G. And those of you who don't do civil, if you do civil work, you know it. You use it in personal injury cases. 233-79G allows you, without having to employ a doctor, by the time you're through it, it'll cost you about maybe $10 between the registered mails and the green cards and all that stuff. And you might have to pay $25 for the records from the doctor, so it costs you about 40 or 50 bucks. I don't care how far back the records go. They go in. You're giving them notice. As long as there's no objection, they usually never object. And I'm not talking about a hospital record that he was taken to the hospital that night where the doctor writes severe intoxication. You don't want that. I'm talking about football injuries, things of that sort, that have a clean medical history, that impact his range of motion, or it's now so that you can get a medical report from his doctor. That's now admissible under 233-79G. There's some case law on that. The point is, you don't have to hire a doctor, but it gives something tangible. The jury, it's in as evidence. It's something the jurors can feel and touch in the jury room beside the complaint. Because a lot of times the judges don't even put the complaint in
I never
to the
put
jury.
the complaint in.
And I agree with you, because it looks too onerous. They have a verdict slip, and they have what other physical evidence. It's usually pictures that we take. It's usually a lot of stuff in 233-79G. Very important, because then you can effectively argue without a doctor that you have to take into consideration someone who is symptom-free in order to take these tests and haven't tried doing these tests in the jury room under those terms and conditions. Any other comments, Judge Rufo, on how you would, we all want to know that because we're taking notes, so we can quote you in court.
No, I think that, Kevin hit on Barbeau. If you don't have the site, it's a great case, and we don't see it really in OUIs. It's 411 Mass 782. It's a 1992 case. It's still very good on 411 Mass 782, and I think you should definitely file a Barbeau motion because it's going to attack and impeach, especially if the Commonwealth's going on the .08 theory. Everything has to do with the introduction of the Toxilator 7200 is the new machine. I think that's the new machine.
The new one is the Alpha-Test 7110. That was close. It was close.
Just
Great.
one thing on field sobriety test, at page 87, there's a jury instruction. It's not in the model jury instruction. It's something that Judge Hayes, sitting in Peabody Jury of 6, developed years ago. I got a tape and I copied it. Nobody's refused to give it. It's very effective. You're hearing from the bench the weight you should give to field sobriety tests.
85.
85. I haven't had a jury of 6 judge not give that jury instruction. Some judges have adapted it.
That's included in my standard instructions that I file. It's amazing to me that it's not in the model, because this is something that, and it's fair. It's fair to both sides, and it's something that's understandable and rational and makes sense, and I suggest that every one of you use it. Yes, sir.
Just prior to testimony, you have a copy you referred to. I found it important to get the year the officer graduated from the academy, because the manuals change.
Oh, yeah.
So you have to get a letter from the.
What you do is you ask for the criminal justice of one woman. Her whole life's work is providing counsel with these manuals, because there's so many requests. That's all she does. And she sends you a certified document. I don't know, that's not admissible in and of itself, but it scares the hell out of the cop on the stand. He's not gonna deny it, that that's him. And that he graduated. Sometimes they'll even give you a photocopy of his record, where he was in the class and what he got for marks. Sometimes they overdo it. And it gives you the name of the book for that particular class. And if you don't have the book, they'll get you the book as well. But once you have the book, they'll send you that letter, and it's no cost. And they know they're gonna have to give it up. What they're trying to avoid is have someone from their office testify on a $30 subpoena. So that's why they're doing it. They're not doing it to be to be helpful to you. They're doing it to avoid being subpoenaed into court with the records. So, because there's no statute on it. But that's the way it works. At this time, yes, sir.
So I didn't mean to interrupt you.
That's okay.
I was gonna ask a question on the, I guess, discovery and suppression kind of issues. If, I see a few times now, for example, there's an accident, no field sobriety, and the trooper will be in the intake room by the nurse's intake notes. Trooper was standing by. A person brought in with a broken leg, and they're given an alcohol screen. And the statute seems to say that it's...
Who's given an alcohol screen?
The defendant. The OUI.
As part of ordinary medical treatment?
That's my question.
What does an alcohol screen mean? I don't know what that term means.
They draw blood.
They draw blood
That's a difference.
for a broken leg or for
Yeah.
a broken wrist.
Yep.
And I'm seeing it come in. I'm seeing it come in.
Kevin, you can comment on that.
Well, yeah, exactly, as the doctor said, alcohol screen, sometimes they'll take urine, it's a very preliminary screening test, sometimes they'll take blood. You get into the issue, obviously, which, you're familiar with, of if it's just a legitimate medical treatment and it's got nothing to do with any subterfuge between the emergency room staff and the police officer, then generally judges will say that it's got no state action, so it comes in. I know the appeals court about, a month or so ago, reversed Judge Phillips on a case out of Attleboro where he allowed the toxicology urine screen to come in, and the appeals court held that that was error. It's a pretty good opinion. Yep.
Okay, what I'd like to do is we're gonna respond to this, okay, in the afternoon, because that's gonna be part of the subject matter of Dr. Benjamin. What I'd like to do right now, though, is we have 20 minutes to do opening statements. I'd like to start with that, because it's so important. Is it the Michigan study? There's a study that everybody talks about. I think it's the Michigan study, that says that 85% of people do not change their mind from opening statement. Now, if that's true, I would think the opening statement is the most important part of what we do in the court. Yes, Doctor?
Dick, let me make one quick comment so we don't lose the continuity. You can never infer impairment on any drug, including ethanol, from urine testing. I happen to be in the seminal case, which was Commonwealth versus Christina Martin, which was also known as the LSD versus the Jello case, that went all the way to the SJC. Neither an alcohol nor a urine drug screen. If you find marijuana and cocaine and barbiturates and amphetamines in somebody's urine, you can only infer a window of time during which they were exposed to it. You cannot infer impairment. So you don't have to worry about a urine. But a blood, you have to worry about, obviously, Fourth and Fifth Amendment rights, and chain of custody. There is no chain of custody in a hospital. And there are about 4 or 5 different types of tests, different methods that can be used in a hospital lab, many of which are very quick, because it's important for the doctor to know whether your loss of consciousness is due to being under the influence of alcohol or drugs rather than traumatic head injury. But the reliability of those tests and the specificity and sensitivity, which are the 2 key words, is always in question. So urines shouldn't scare you that much. Blood can scare you.
Okay, we're gonna have an opening statement, but what I'd like you to do is if you'll turn to the problem, which is on page 1, I guess, yeah. You can keep it in context of what's being said. So we're gonna have an opening, we have a presiding, one of the judges can, yeah. Judge Coffey is presiding, and the case is Commonwealth versus Oakstein, who's a colleague of mine in my office. I just put him in there just to feel comfortable.
Ladies and gentlemen of the jury, members of the court, rarely in life do the good decisions that we make bring us before a criminal court. It's often the bad choices that we make, and that's the reason that Michael Oakstein is before you today. Michael Oakstein is a good man with a good family, a good job, a good education. He pays his taxes. He served his country in the military, in the Marines. And until March of 2002, he was a law-abiding citizen. On that date, he chose to have a few drinks too many and to get behind the wheel of the car. And it was those bad choices that brought him before you today. You'll hear evidence from the Commonwealth today from Officer Sean Sheehan, who came upon Mr. Oakstein in the early morning hours of March 1st, 2002, on Route 2, heading toward Lexington. Officer Sheehan will testify that the defendant was driving at a high rate of speed, that he pulled him over, and that he, from that point, administered some field sobriety tests to Mr. Oakstein. Those field sobriety tests were for the purpose of determining whether or not Mr. Oakstein was capable of driving in a safe manner. Under the laws of the Commonwealth, an individual commits the crime of operating under the influence of alcohol when he drives a vehicle in such a manner after having had intoxicating liquor that his ability to drive is impaired. His ability to drive safely is somehow compromised by that alcohol. How many drinks does that take? I've told you that Mr. Oakstein had a few drinks that evening, and by his admission, as you'll hear from the officer, he had a few beers that evening. Now, how many beers is too few? How many beers is too many? For different individuals, it can be different, and you'll hear that today. But whether it be 1 beer or 10 beer, when the alcohol one consumes diminishes one's ability to drive safely, one's ability to concentrate, to reason, to respond, to react, to use motor coordination and skills of judgment that are important in driving a vehicle, one is operating under the influence of alcohol. You'll hear from Officer Sheehan that 4 field sobriety tests were administered that evening: the alphabet, the finger to nose, the one-legged stand, and the 9-step walk and turn, and that all 4 of these tests were failed by the defendant. You hear a lot about burdens of proof in this case, and the Commonwealth at all times bears the burden of proof in proving that every element of the crime was committed beyond a reasonable doubt. I'd ask you to listen carefully to the evidence that you're going to hear today from the officer. Listen to it and use your own judgment, your common sense, you're also going to hear another side of the story. You'll hear from defense what they believe happened on that night. As I said, from the Commonwealth, you'll hear evidence. From defense, you'll also hear evidence. You'll hear a number of excuses. You'll hear excuses as to the conduct, as to the failure of the tests, and as to why the defendant was unable to commit those tests properly. I'd ask you again, keep an open mind, listen to all the evidence before you, and I'll come back at the end of the day and after the case is put forth before you and ask you to return a verdict of guilty. Thank you.
Your Honor, Mr. Assistant District Attorney, members of the jury. Ladies and gentlemen of the jury, what the Assistant District Attorney just told you, that's not evidence. It hasn't been proven, least of all proven beyond a reasonable doubt. And what I'm going to ask you to do is I'm going to ask you not to form any opinions, draw any conclusions, or make any judgments in this case until after you've heard all the evidence. Until after you've given Mr. Augustine the opportunity to cross-examine the Commonwealth witnesses. Until after you've given Mr. Augustine the opportunity to present evidence. And he will present evidence even though he doesn't have to. It's important, members of the jury, that you understand that Mr. Augustine need not do anything. That he sits here and he is innocent. That all the burdens rest with the Commonwealth. However, I expect that during the course of cross-examination and evidence produced by Mr. Augustine, you'll hear that he's a 32-year-old married father of 3 children, that he was honorably discharged from the United States Marine Corps, and he's employed as an engineer. Ladies and gentlemen of the jury, you'll hear testimony about where he was, what he did, who he was with, and how much alcohol he consumed. You'll hear testimony that he awoke, he went about his day as he usually does. He had a late day at the office and had plans that evening to have dinner with business colleagues. You'll hear that he consumed alcohol. He told the police officer he had 3 beers. Listen closely to all the evidence. Hold the Commonwealth to their burden. Listen closely to the cross-examination. Look at how Mr. Augustine responded to the signal to pull over, responded to the officer's request for license and registration. You're going to hear testimony about certain so-called field sobriety tests. And the judge will instruct you on those tests at the conclusion of this case. Pay close attention to the weather, the lighting, the circumstances under which he submitted to these tests. Ladies and gentlemen of the jury, all I can ask you for at this moment is your time, your patience, and your consideration. I trust you'll give that to Mr. Augustine. Thank you very much. Thank you, Your Honor.
Good. How would you respond if you were asked, and if it was objected to on the opening of the district attorney, you'll hear from the defense.
I wrote
You'll hear
that
them
down.
make
Yes.
excuses.
Yes.
That's,
That's,
can't do that.
that's impermissible. I would give a limiting instruction. I would remind the jurors that the burden of proof remains with the Commonwealth throughout the entire trial, and that the defendant is under no obligation to say or do anything. And I would be disappointed, quite frankly, if defense counsel did not object, but I would do it sua sponte.
'Cause that's been done. It's so tempting because the defendant doesn't have to do anything, but they know. Not only is he gonna be there, he has witnesses there. And so in anticipation of that, prosecutors sometimes say, yeah, you're gonna hear from them, but it's really our story. We have the burden, et cetera, and so forth. The saying that you're gonna hear from them is the part that's objectionable. The them doesn't have to do anything. What questions do you have on openings? This is the time. Yes, sir.
Yeah, I'm confused because if the Commonwealth says you're gonna hear from them and leaves it at that, is that objectionable?
Absolutely.
It's the excuses that's objectionable.
Well, I think what the prosecutor said, and because I did write it down verbatim, you will also hear evidence from the defense. And the defendant is under no obligation to proffer any evidence. And the last person who can promise a jury that you're going to hear evidence from the defense is the prosecutor. So that's why it was objectionable.
Because I reacted to the excuses, not the proffering
I
of
know,
evidence.
that's why I
They
threw it
don't
in.
do it anyway.
But they don't have to, and the jury has been instructed that they don't have to do anything. The judge has already made a preliminary instruction that the defendant sits before you innocent of all charges, doesn't have to do anything, doesn't have to make an opening, doesn't have to make an opening at this time. It's a standard instruction
Right.
that you give, and that flies in the face of that instruction, yeah. Former prosecutor, go ahead.
Judge Parker, you wouldn't consider a motion for a mistrial at that point after they put that
No.
out there to the jury?
Oh, well, I'd consider it, but I'd deny it.
Yes, sir.
The comments on the law, like, a DA giving his own instruction.
Right.
Which wasn't correct, wouldn't that draw the same kind of reaction from the judge?
It could. I make it as part of my closing. I always remind jurors, because I find that it's more frequently employed in closing arguments than openings, but I will remind jurors that what the attorneys might have represented to you as law in Massachusetts, you should not consider, you should not even entertain, because that is not their function or responsibility. That is the court's responsibility. That is my duty. So if in fact one of the lawyers did tell you what the law is in Massachusetts, just disregard that. But I use that as part of my standard closing. But I do think if you were to object and ask for that type of instruction right after an opening, that would be viewed by most judges as a reasonable request.
Kevin?
Actually, I take a different approach to it. I thought the prosecutor, I try to sit here and act like I was a juror, and I thought that Sandra really did a nice job in the sense of presenting some of the favorable points. The guy is a, father and husband and served his country, but he committed an offense. And I think what's important, from my point of view, on an opening statement, it's hard enough to get up there, especially like if it's a murder case, or something on an OUI case, if it's a bad one, maybe a homicide or a fourth or third offense or something. It's hard enough to get up there if you're a defense counsel, and I imagine as a DA, if you know you have a thin case, and present the believability to the jury in the opening statement. We spend too much time worrying about, well, can I say this? Is this going to be a comment on the law, and can I say that? You have to have the spirit, and you have to have the passion and the believability when you get up there in front of the jury. And that's what I think that an opening statement, as Dick said, many jurors walk away with a feeling, and I'm not saying to just disregard the law by any means, but you can't be tripping over what you can say, what you can't say. You just have to get out there and present your case with some believability, and that's what I think is important to do.
Yes, sir.
What's the burden of proof for a prosecutor in an opening statement? You might say it's not a waivable issue for them. And I've had situations where DAs are maybe less than prepared.
They won't require finding on an opening.
And they may skip in their opening statement something like public way, something of an element.
I think your question is, do you make a motion for required finding on an opening?
I have,
And-
it was unsuccessful.
Yeah.
But it points to a question as to what is the burden of proof for the prosecutor when they're required to make an opening statement.
Judge, go ahead.
The burden of proof is that they must establish all the elements, that they're going to be able to prove all of the elements. But, I mean, you raise an interesting question where there has not been a stipulation as to public way, and if a prosecutor fails to mention that this occurred on a public way, or fails to even give the location, whether that would warrant a required finding. Quite frankly, I'd be inclined not to give it to you.
I think the
Let
case
me
law says
just-
that you can reopen.
Yeah, case law is on that.
Yeah, you can reopen. The better tactic to do is sit there and hope and pray they leave it out in their case, and at the time they rest, it's a lot more difficult to reopen once they've rested, and raise it at that point.
Yeah. If I could just comment as well on Sandra's opening, I thought that it was very effective, and you don't see it happen that often, that a prosecutor will paint, quite frankly, a very sympathetic picture of the defendant, and appeal to the juror as being a reasonable prosecutor. I mean, this is a reasonable prosecution. We're not out to get this guy. We recognize that he is an upstanding citizen, but he made a mistake that evening. So I just wanted to mention that.
We have time for one more question. Yes, sir.
I just wanted to ask some of the practitioners. I know that with the defense argument, it seemed as if they were saying, well, pay attention to this, this, and this that's coming up, and then ladies and gentlemen, the jury will be able to make their own decisions. I find that I've been doing a little bit more storytelling and putting my facts into my opening, even though you want to withhold things. Do you find that you want to kind of lead with your best shot and start with, under that Michigan theory, 85% make up their mind right away? I want to go and say, this guy is a great guy. He wasn't drunk driving because of this, 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 and the evidence is going to show that you're going to want to make the DA apologize and give $25 for his effort.
Kevin?
But instead of, I'm exaggerating the point, but I find that I'm giving more of my case away in the opening just because I want the jury to make up their mind that, hey, they got to overcome the fact that this is a good guy, that this is what he's doing, and he wasn't drunk that night. Do you disagree with that, or do you think it should be held back?
I would agree with your point of view. I think that it's good to put some of the facts in the opening. If you have it, just as he commented, I thought was very good too. Defendant does not have to testify. We call people defendants. They don't have to defend against anything. It's the government's burden. But nevertheless, I remember Jack Atwood would always say to a jury, you're a very lucky jury because you're going to hear from this guy and you don't have to hear from this guy. I think that I agree with you. I think just giving a little bit of what your defense is, if you have, I get an EMT, you're going to hear from an EMT that saw the guy's eyes and smelled his breath and made observations of his standing and walking and talking as he stitched up the bloody eye, that type of thing.
I think, if I could just comment, I think you always have to be cognizant, too, of the fact that timing in life is everything. And for the opening, usually everybody's still wide awake and you have everybody's attention. So first impressions are lasting impressions, and you don't get a second chance to make a first impression. Unfortunately, a lot of times by the time in the day that you're putting on your case, it's after lunch. People are a little snoozy, they're looking at the clock, they're a little annoyed that they're still here. So what you think is going to really just impress them and blow them away, they may hear, but it may not register.
Here's one other comment. If you know you're gonna put your defendant on it, what I like to do, and again, that's just one point of view, is I like to tell him that this defendant, this person, this John Smith, wanted to tell you the day you got arrested, but wants to tell you right now what happened, but he can't, because that's not how a trial works. He wants to get up off of that chair and get on the stand and tell you. He's been wanting to tell you since August 23rd. And so, but you gotta fulfill that promise. You have to make sure that you get him on the stand. So you're asking to keep...
Yeah, I guess.
Yes, Doctor.
Dick, I wanted to just add one point to your opening, George, because what we heard from the government was that the defendant admitted to having a few beers. Then what we heard from the defense was what he had was 3 beers. Now, I think it's very important that when you mention the 3 beers, you also mention the time span, because 3 beers drank really quickly on top of one another might cause you to fail the field sobriety test. 3 beers in 3 hours, you're going to have a 0 BAC, because you're going to put in about .02 and you're going to burn off about .02. And I think it's Doolittle versus LMR that talks about how many drinks that person admitted he would have before he became drunk or intoxicated, but the time span is never given in that case law, and that's a faux pas.
I wanna thank our panel. This is terrific. I'm learning a lot. It's a fantastic job. Thank you very much. You never know how these courses are going to work. We've all been to them. This one here is, in my view, particularly compelling because of the people that we have here. We're going to stop, but please promise me this, that you get back here at before 1 o'clock, because the heart of the seminar starts at 1 o'clock. So we don't want to have to be dragging you out from the corridors. 1 o'clock we start sharp. Thank you very much.
George, I would just add on, you're going to hear from our expert that 3 drinks in 3 hours is not high enough to cause any type of impairment in motion.
Yeah, no, I get that. That's a good point. That was. But what's worse than the closing, the DA stands up and says, you know what? Believe Mr. Oakley, this is what he had, but it was one too many. Yeah, it's just really, yeah, I'm looking at it as a big audience, but I think it's still okay. I think I've done better than you. I don't promise you so much. Give you something. Oh, what you haven't done. What's up there, Phil? I'll tell you, that's about it. No, but I had to go to the assignment. Yeah, but the book covers really does. I'll tell you. Audience.
I would be sitting there, I would say, oh, it's I don't like to do it. Wow. That's why you have to. That kind of, you know what happens is, essentially, the month that changes, I don't think you want that. That's what I'm about. If you did, you'd kill us.
That's not the
George, Adam Credit with real quick one. Nice seeing you. On the audit sheet, they're talking about discovering that audit sheet.
You done?
I'm attempting to do. I've tended to do it on other types of cases too.
I think you can get it. I don't really use it. I try my cases on the issue of perception.
Oh yeah. Perceptive case. I like the thought of the audit sheet, but I've tried it twice, fishing twice. What's it going to get you?
The breath test stuff is very interesting. I thought it was going to make me this guy. Oh, it's horrible.
I just lost it. It was very generous. It was just a warning when you allowed him to instruct him.
That guy was good.
I wanted to plead his court. To win in the world at the same time.
Judge Bucco gave us in the book.
Oh, you mean the annotated?
Yeah.
Oh, yeah, no, that's good. I'll let you go.
Yeah, it's good to see you.
It's beyond their care.
It's very, very difficult. What you should
Very nice.
Where am I going? Third? Fourth floor, okay. I'll get it. Yep.
All right. 6 hour window. 6, I believe it's that.
What do you mean that?
You do, okay.
Can't get anything around here that quick.
Call the one. All right, then, so I'll be back here. You got the drink?
you get the 50, the more ambulance spots.
Careful, I don't go at night, my wife finds that to be extraordinary. I would have been.
This is why I wonder what people like guys like you are doing, because, you know, you put somebody.
I'm not doing anything, I just tell people, I just say, look, here's where I look at it. They have to prove this, and now they're gonna be okay, fine. I do exactly what they said, I said, it's a big problem. I'll document you that.
Good.
I don't care.
Now, when I get up, I'm gonna go in the next 5 to 10 minutes.
Oh, yeah.
Yeah. Right? Areas. I think it's time the guy goes, stick around for another 2 hours, you're gonna do another show, what do you think of that? I said, now. Oh, shit. Think of what, right? I got my service.
That's all they need to start.
Yeah. Oh, prove, you know, reasonable doubt, but it's, I actually had one. It was like, Jerry found a kid, and I told him, I mean, it's just, so they go and they feel bad that they fucked it. On the other, see, I found originally, like, Jerry's pissed, it's occurring right here, it's shit. I thought it was a I was the other side, they feel bad for me, and another thing.
Well, let's say, Kim, you know that they got the start already, they're ready to introduce the amendment complaint. Now, all of a sudden, you can be crying 15 years ago.
Right.
I can go in front of Aggie. Was Aggie out there?
No, right here, I used to be, he's a good guy, he used to be in, medical.
Good guy, I think.
I think it's great.
Yeah. Anyway. Yeah, Kevin's a good guy. Kevin's hanging out with Tommy. My cousin. Tommy O'Neill, her son.
Oh, okay, yeah. No, Kevin's a good guy, I knew him when he used to do a lot of federal shit.
Well, anyway, so say your client says to you, okay, listen, can you get me a 24D? It's more than 10, so we can do it like the old 6 and 10, let's say.
Right.
And give me the 24D. Now, I don't know if anybody can see a 45-day loss on that. I don't know if the judge has a discretion to give you the 2 years because it was considered a second.
That's right, registry will consider it to be a
So
second.
he says, but okay, you give me the 24D, I know I get my license back in 3, 5, 6, whatever.
Yeah, but
That's
the
the tough.
registry's still not gonna
Yeah, they are, as long as you get the 24D.
even if you have 24, I'm telling you right now, because I get the same.
I got it to happen, I got
Well,
it.
it depends on who you get for your.
That's it, I got it tonight, but
I got it, same 12 years ago or whatever, they call it, one or it's an 80.
I talked to
It's the worst person that you could have done it to. She said, no, second place. I mean, I took care of it. Yeah,
so we got it because the 24D, you know, I know the Romney's trying to do something about that.
They're gonna change them. They're gonna change, anything that's beneficial, they're gonna change. That's okay.
All right, let's- Oh, man, you know, well done. Fantastic. You did some work.
Hello, my friend.
I spoke to you recently on the phone, but I can't remember what it was about.
It was, the whole idea is to be as quickly as possible, because otherwise you get judges.
Hey, you don't talk, kid.
Sorry? Back in here, so we.
Okay, my secretary. Oh, yes,
So, it's pretty.
She never answered our calls. So, you know, if we found it, it was great. Great kid, we're really happy with it. She's been with us now for about a month. I ain't happy with it. She's
I
just,
give
before
you a
she's supposed to
couple
get there,
options.
doesn't leave right away.
One,
Very
I
good
have.
phone voice, very nice manners. So we're very happy.
Can I use your skills for a moment?
Sure. Let me get my eyeballs. I got them in the bag over here. I didn't used to be there. I just complained to the dentist about, you know, I said, gee,
Complain to the dentist, you could say.
I'm almost 50. And I, you know, it's like, I have to go to the bathroom all the time. So my wife's a nurse. You have to go more than one time. Oh, you have to go more than one time.
You forgetful, Thursday.
Oh, what's happening to me? I haven't drank yet. It's too early.
Here's how you get started.
Sure. This your case? Listen, police OUI?
That's fine. Okay. What is, it is, what I'll do is this.
Okay.
Pretty straightforward. He's driving along. Oh, look at that, okay.
Okay. Plus, the cop report, so it's very short.
Good. Yeah, it's Nelson. Yeah, that's right. Okay, yeah, thank you.
Good. You know that, my son's friend called, and I told my husband, hey, they might let him go early, he didn't call. So I said, hey, get going. And look at that.
They're releasing the rally, right?
Good for you. Oh my God, great. You know, it's just really
Phone call won't do it, that's written.
That's.
Does he have an epilepsy problem or something?
I went upstairs. So everybody was out of their offices, I couldn't go in an office.
Oh, that's.
His phone is inside the car?
I think it's one of the ones.
The ladies' room is, a little tricky to afford. This is my pocketbook, so I gotta carry it. I don't remember.
Wow, this is snowing quite a lot.
Yeah. And,
Three homes to the state.
I almost didn't send my son to school for the month. But then I said, nah, you know, he's already missed one day. I don't want him to think that it's okay.
Does he charge a local container?
There's not.
Well, I think you got most press in that bag. Is he in the, okay, the hypo's, is he in the program?
He's not.
You know what I mean?
But
They give you a license to have
But
people.
he does tell me that a long time ago, he had a card. I'm trying to find it.
It's a very tough. Can't see anything. This is what it says. He's got 10 years. He's just a kid. He's 10 years old. He's only knows all this stuff, but he can't. Kid in the car, people are gonna flip out on that.
That's where we are. In court last week, promotion suppress hearing.
It's got a 51A on it.
Yeah, we saw that went away nicely. They took his license, but his license back right away because it was OUI drugs, not OUI liquor. So they had no right to take his license. But now we're in court. We want for motion to suppress. I'm trying to resolve
the
this
beams.
case. In the beams. For some reason, the prosecutor, first of all, Judge Ford is who I put for truth.
Okay, you lost.
I lost before I even started. But the prosecutor wouldn't negotiate. So just get rid of a couple of charges, not a couple.
Yeah.
Okay.
What's wrong with that?
So I ended up going, he ended up just dismissing possession of hypodermic needles and possession of Class B. Because
Who dismissed this?
This is,
The, assistant?
the DA is Carlos, what's his last name? Usually.
What's What's he look like?
Yeah, I guess he's somewhat Hispanic.
Hispanic looking?
Not really Hispanic looking, but he's Hispanic.
Okay.
Carlos or,
Oh, is he a real good looking kid?
yeah,
Looks
yeah.
I think I know who he is. Yeah, yeah. He used to be a defense attorney and came over all the girls with Google all the office things. Oh, Carlos. I think I know what I mean. He's a good looking kid, right? Yeah, I know him.
So he would drop the Class B and drop the hypodermic needles.
Yeah.
Now he admitted on OUI drugs, operating to endanger, possession of date.
So he's lost a license for 1 year, right?
I was asking for, who knows what all this new law stuff was,
Yeah,
so
yeah.
at the time I was naive, and guess what, I don't know. But I didn't want to take some of this shit, I didn't want to lose the license on D for a year.
Okay.
So I asked for continued autofinding on this one.
Okay.
Asked for guilty probation on the other ones.
Okay.
Which is a fair situation, because,
Sure.
one, this is his first
He's giving them
offense.
something.
It's his first
Yeah.
offense, okay? No other OUIs. But the problem is, he's got a long record. With the long record, most of the stuff we resolved very nicely along the way
Sure,
of life.
sure.
Until from 96 to 99 or something, he takes a couple good drug hits because he's using it, he's trafficking and he's doing all sorts of stuff, and he's 3 years in the state prison.
Okay, all right.
DA's looking for time, okay?
On this case?
He's looking for time, okay? He's looking for a year on the OUI, 2 years on and off on the operating to endanger, and a year on and off on the Class D. To me, it's like, what the fuck? What's with you? Where have you been? Well, this is sick.
I thought Carlos was reasonable.
He's going back to
We're
his,
talking about the same guy.
maybe not, he's going back to his boss.
Light
'cause-
skin complexion,
Yeah.
good looking kid.
He's going back to his boss because that's who he's getting all his orders from. He
Yeah.
couldn't even dismiss some of these charges without talking to the boss first. Go before the judge in admission. And the judge says, okay, yes, 1 year on this, yes, 2 years on and after on that, but I'll be nice, I'll give him this concurrent. And I'm saying, Judge, you want to give him 3 years in jail?
Yeah. This is Ford.
This is one.
Yeah. Boy, I got away from him just in time the other day. Oh, it was terrible. I had to beg to get out of there.
He was sitting in the assignment session.
I was there when this happened on Thursday. This happened on Tuesday. I got a second, I think. Guy's got 5 kids. One of the tight ones.
Yeah.
5 kids, married, lives in Braintree. He's a postal worker. Irish
He
descent.
drives.
Oh, no, get this, even worse. You know where Murphy's Law is in South Boston, Powerhouse Pub? You know, it's right across from the Edison right there? Okay. 2:13 in the morning, dispatch gets a phone call that there's a man blocking the driveway to the bus terminal that's out behind him. You know where the bus terminal is up behind him? Of course, my guy says it wasn't really technically got photographed. This is where my car was. But anyway, they get the phone call. The cops go to Murphy's Law. One cop goes into Murphy's Law. It's 2:13 in the morning. He says, whose red van is that? You better move it or it's going to be towed. My guy raises his hand, and my guy says, I said, I'll go move it. He denies he heard the rest. The police report says, I said, no, not him, get one of your friends to do it. Who else? Murphy's Law, 2:15 in the morning, is going to be driving a car. Who'd want to drive a car? What a cop saying, move the car. Right, so my guy goes out and moves the car. Now, there's no gas.
Hold on one second. Cop orders him to move the car.
No, he says to him, not you, get somebody else. My guy thinks he's going to do it. Right? Now, I don't know if that goes more towards intoxication, but what he's saying is, it's inside this bar. I know it's my car. I don't hear anything else he says. All I hear is, move the red van or it's gonna be towed. That's all I hear.
Why would he say not you? Unless you already know
In the
something.
police report, it says, Mr. Morris raised his hand and said it was his. And I said, no, not you, have somebody else do it.
I think you can get enough people from the bar that night to say, no, we never said that.
No, we don't even include it.
He does. Is he regular there?
No. What happened was this, he was at someplace else in South Boston that night. He leaves, he notices gas gauge is practically empty. His nephew, Brian, hangs out there. So he goes to this bar. This is why I get some evidence that he was only recently there, because the dispatch only comes in at 2:13.
Perfect.
See?
And this bus comes every 15 minutes,
Oh,
this bus
whatever.
comes. Clockwork.
Whatever.
No, but that's important.
Yeah,
It's
so-
important to show that this bus route is every 5 minutes, the bus comes through.
Right. So what happens is, my guy says he's banging on the door, trying to get entry. Because the bar's already closed, it's closed for the night, trying to get entry. And after banging and banging and banging, the bartender says, wait a minute, it's Brian in there. Brian isn't there, but then he says, well, maybe there's somebody else, maybe he can make a phone call. He doesn't own a cell phone, maybe he can make a phone call. So all this takes place, then the cop comes in, whose van is this? So all happens within 10 minutes. My guy gets out, drives the van, only has a little bit of gas, but he wants to get on a residential street where it won't be towed. So he goes goes the wrong way on K Street. The cop loops around, arrests him. Now the cop says, I stopped him. I asked him to get out. Now the cop does help me in a certain way. First of all, the cop's sorry that he arrested him, because every time I have to listen to his apology. You know? So what happens is this, my guy's wearing flip-flops in the summertime. He says his foot got caught underneath the brake when the cop asked him to get out. Of course, the cop says, well, he was falling out of the car. But the cop does say in the police report that he was wearing flip-flops. Right? Then the police report says that he had bloodshot eyes. And it also says he had brown eyes. My guy's eyes are as blue as mine. I don't think the DA's noticed that.
So he had brown bloodshot eyes. Ladies and gentlemen, with the help of medical technology.
You know, like Heinz says, I was really full of shit that night. Now, the police report says they had glassy, bloodshot eyes. And then on the description part, the booking page, and up the part, Boston Police Report, how they give the description of your guy, right? They put brown hair, brown eyes, you know, like, and it says it more than one spot that he has brown eyes, and his eyes are as blue as mine. Yeah. So what happens is this. I go there Thursday, BMC. There's 120 cases on the docket. Charlie Johnson's on the bench. The clerk says, before I get in there, John Bartlett, he says, well, we're never going to get to this list if we have any long-winded attorneys. So he goes like this, so I go into the case, my case finally gets called about 11:30. Fine, it's ridiculous. Everybody named William. I said, get ready. So finally my guy gets called. Judge says, ready for trial? I says, I'm ready for trial, Your Honor. The DA says, we're ready for trial. Okay, you're going out to Judge Horton. I said to him, I said, Your Honor, this is my mistake, I should have done this. I said, Your Honor, I can't go before Judge Horton, former colleagues, which is true, he's in my office, became a judge. And he says, thanks for telling me. And he goes, you're going to Judge Ford. Oh, now just bend over, right?
Judge, I can't go before Judge Ford. I have to represent my client fairly.
I should have said she tried to pick me up. So anyhow, in fact, I think she did. Because I was at a Christmas party once, and she came walking up. She's an attractive looking lady. She comes to me and she says, haven't I seen you somewhere before? And I said, well, yes, you are. I'm a lawyer. Like that. But anyhow.
Judge, can't go wrong. We have a formal relationship also.
So anyhow, what happens is, I can sit for Judge Ford, so now you don't talk to me because I have the choice of Coyne, Flaherty, even Dugan. You know, Somerville, I would take Somerville. Anybody but Ford or right? Anybody but then, I take, I try cases from him. I let you try the case because he whacked you if you could lose, but at least he let you try the case. At least he knows the law. So what happens, I end up going into Ford's, it's like 11:45. She's already got a jury trial in progress in a school zone case, right? She says, well, come back at 2 o'clock, we're in panel. I come back at 2 o'clock, I see the assistant DA. Now it's a different assistant DA. She says to the judge, we have 3 police officers. Now this case has already been up for trial 3 times before, but it's a South Boston case, sent to Dorchester, and then after 3 times in Dorchester, it's now in the BMC because they changed the rules. Because all the jury trials go. So she says, I got 3 police officers. I said, Your Honor, this is what 3 times before. This is the first time I heard they had 3 police officers. Oh, we got 3 police officers. And Mrs. Diaz says, oh, by the way, I have a certified conviction of your client's case at Quincy. And I said, well, that's not enough. Which is, well, that's why I'm going to be asking, that's why I'm telling you now. She said, because I'm going to be asking for a couple of days in order to speak in a bit of police officer. I kind of, it's not going to reject that.
That's a pre-change in law case, right?
Yeah.
Okay.
Yeah, pre-change of law. So what happened was this is, the judge now starts closing arguments on the cases already before her. Closing arguments don't even end until 3 o'clock. She gives the charge, right? Now it's 3:30 in the afternoon. I finally get before the judge. It's 20 minutes to 4. Now before, I used to be close. Before I do what you call my friends. Jury purposes. Jurors. This is all that. That Judge Ford told us to say she does it to us all the time. Holding jurors, holding jurors. These people are all mad down here. You know, they got because everybody thinks you're going to be out at 10 o'clock, you know, like they used to be. So anyhow, what happens is this, I come back, and I said to my client, I said, we're going to ask for continuance. So I'm going to ask for continuance. The judge said, oh, well, Mr. Finley, you answered ready for trial. I said, that was at 9 o'clock this morning, I was ready for trial. I said, I told you at the beginning, Your Honor. I said, I got a seminar on Friday, and I can't miss it. And I said, with 3 police officers, there's no way we're going to finish in one day. 2 civilians and 3 police officers. No way we're going to finish in one day. The DA goes, oh, I misspoke, Your Honor. We don't have 3 police officers. We only have 1, and he's on a detail, and he'll be available at 4 o'clock. I said, Your Honor, that's outrageous. What is this, a trick? I said, they answered ready for trial, and now I find out at nearly 4 o'clock in the afternoon, the police officer's not even here, he's on a detail? I said, this is a way of the Commonwealth to dilatory this case, so they can have their own